And with that very brief introduction, I'll hand over to Andrew and Courtney.
Thanks, Carmel. Before Andrew and I launch into the topic, we'll perhaps say a few more words about ourselves, particularly how we ended up working in civil law jurisdictions and what our arbitration caseloads look like. Andrew, would you like to go first?
Thank you, Courtney. So good morning to everyone. I started working in Italy as a foreign lawyer as part of a legal team representing an Italian granite supplier to Australia for a well-known Sydney skyscraper. And in international, let's say, commercial construction arbitration with seat in London. Previously, I'd been a solicitor in Sydney with the New South Wales Ombudsman. During the 2-year arbitration based in Italy, I began studying Italian law. I was based in Rome, which lasted several years, and then assisted me to obtain admission as an Italian lawyer over 25 years ago. Having spent so much time achieving the goal, I remained in Italy and have practiced here since then, but doing both transactional and contentious commercial work. However, the common factor in all of this is that my work involves almost always international elements, that is private, international, substantive, or procedural law. In arbitration, I work both as a party counsel and as an arbitrator. When as an arbitrator, normally under the ICC rules or the Milan arbitration rules. So I hope that wasn't too long. And over to you, Courtney.
Thanks, Andrew. So my journey in international arbitration began as a junior lawyer at Norton Rose Fulbright in Perth, back in the day with Carmel. I was staffed on a CTAC arbitration. I didn't see that arbitration to an end. I went and worked for Justice Mazza at the Court of Appeal in WA, after which I packed up and moved to Switzerland to do an LLM in International Dispute Settlement at the Graduate Institute and the University of Geneva. And then I just stayed. I got a job here at Lelive, and I've been in Zurich for 7 years now. And I practice exclusively in international arbitration, predominantly commercial arbitration, and I also from time to time do some investment arbitration. I mainly act as counsel, and I also sit as arbitrator and tribunal secretary. And I've worked on the cases under various applicable rules and applicable laws, but I would say that the lion's share of my caseload would be ICC and Swiss rules, with Swiss law as the applicable law. Now, perhaps before we jump into the substantive discussion, Andrew, we had a bit of a discussion as to how we understood the topic. Would you like to share some insights into how we've tried to refine our discussion to touch on all the high points and get all the sound bites across in the limited time we have today?
Yes, it's okay. There are a few caveats to this. When Mark first mentioned the topic to me a couple of months ago, I thought for me, practicing in Italy, it would be quite a simple exercise, but during discussions with Courtney and the preparation meeting that we had, we realized, I think, that it's not so simple. There are a few caveats, let's say. Arbitration, of course, developed domestically in both England and also in continental Europe and perhaps elsewhere. Also, when we talk about civil law, we're talking about civil law in Europe. And really, we're talking about civil law in two jurisdictions, Italy and Switzerland, because perhaps differently from common law, there are many variations in civil law, and that has been the difficulty with this and why the topic is a bit nebulous. So it more than perhaps considering which came first, the chicken or the egg, or whether one influenced the other, I think we're really talking about a process of fusion for transnational disputes. And that fusion, of course, has taken place over a significant period of time. I haven't studied the history, but perhaps we can, before the New York Convention, so over 70 years ago, and that process has been continuing. There are also significant approaches, as I said, for instance, between the German-Swiss approach, which we consider more inquisitorial than the Italian or Italian-French approach. So we'll discuss what we have identified as civil law influences at various stages of the arbitration process. Some are quite clear at the start of the arbitration, and I'll hand over to Courtney for that. Others certainly exist, but perhaps are less clear to identify during the fact-finding stages, the fact-finding process of an arbitration, and also, of course, regarding the management of an arbitration where those influences do exist, but they may also be cliches, I mean, in all of this as well. So, Courtney, I think you're going to say something about at the start of an arbitration, some principles.
That's right, Andrew. We didn't intend to say too much on the start of an arbitration. The meat is really in the fact finding and the case management. But just to remind everybody that in international arbitration, we have these well accepted principles that when a proceeding begins, separability, competence, and good faith prevents a bad faith party from hindering those proceedings from getting underway. And we wanted to just remind everyone of the civil law genesis of these principles. So turning firstly to the separation principle, which assumes that an arbitration clause is not affected by invalidity or termination of the main contract in which it appears because it exists as a separate agreement from the main contract. Switzerland was the first nation to recognize a fixed separability doctrine in 1931. And thereafter, separability, the doctrine was recognized by the ICC in 55, by UNCITRAL in its arbitration rules in 76, and then in the model law in 85. And since then, various arbitration rules have provided identical provisions on separability as those contained in the UNCITRAL arbitration rules. And non-model law countries have enacted modern arbitration statutes which acknowledge the doctrine. So the main corollary of the separability doctrine is the principle of competence, which we all know gives the arbitrators the power and competence to decide their own jurisdiction. Now, it should come as no surprise that as a procedural tool of the separability doctrine, competence also has its roots in civil law. It was born out of the jurisprudence of the Federal Constitutional Court of Germany. And today, competence, and separability are enshrined in the model law and the UNCITRAL rules, and therefore they're really well established in international arbitration. And perhaps, Andrew, you want to say a few words about good faith before we move on to the juicy part of the discussion?
Very briefly then. Courtney mentioned that good faith at the let's say to preserve or protect the arbitration clause, but of course good faith pervades the arbitration process if we consider it at least from a civil law point of view. But in Italy, from a substantive law point of view, that is also the agreement to arbitrate. We have various principles of good faith in the civil code. One is that there's an obligation to negotiate in good faith. And if you break off negotiations, then you can be liable to pay damages. Also, to perform a contract in good faith, to interpret it in good faith. Also, if your contract agreement is subject to conditions precedent, to behave also to protect the interests of the other party until the condition takes place. There are many. Also, and they are all, let's say they are all pervading. So there's a requirement in Italy that you also act in the interests of the other party in your dealings with the other side, not to unduly damage the other side. So this approach is very different, I think, from the common law approach. There's also a procedural article in the Code of Civil Procedure. If a party acts in bad faith during the proceedings, then a judge can order a party to pay damages in an amount which is equitable, let's say. So there are three, let's say, principles which are significant and perhaps clearly identifiable, although not necessarily so, let's say, in the case of good faith as to their effects. But moving now on to let's say that the key areas, the key stages of an arbitration where civil law may have influenced, let's say, the fused system. Courtney, would you like to kick off with that?
Sure. Let's kick off from the start with how parties open proceedings. They typically open proceedings with written submissions. Now, all parties open submissions in a way which they narrate key facts, they set forth a legal theory, and they ask the tribunal for a remedy. However, there are differences, significant differences, in how precisely the written phase of a proceeding develops in different legal traditions. So, as we all know, having hailed from Australia, in the common law tradition, the written phase typically occurs in a staggered fashion, with parties providing limited factual information at the beginning in the form of pleadings, and only later exchanging the evidence upon which they rely, and thereafter legal arguments or arguments supported by legal authorities. However, in the civil law tradition, the written phase takes a more front-loaded approach. Parties typically submit a full memorial in support of their case in the form of a statement of claim or defence. Same name we can find in common law, but the difference being that all evidence upon which a party relies is submitted with that statement of claim or defence, and then in the second round, the reply and rejoinder. And this front-loading memorial style in civil law has really been transposed into international arbitration. It's standard practice. You'll see it in many of the leading institutional rules as a recommended or assumed approach. I won't say much more on pleadings versus memorials. There is, I will just give Akika a shout out, a very helpful note, an explanatory note on the differences between pleadings and memorials and the arguments for and against the use of both. Andrew, has this also been your experience in your practice? I think you're on mute, Andrew.
Thanks, Courtney. Absolutely so. In the term you used, which was front end or front loaded, is absolutely the case. So court proceedings in Italy kick off pretty much like we would see in international arbitration these days, and there is. Early on in the proceedings, there are cut-off dates for the presentation of documentation by the parties, and so that is very similar. How much it has been an influence, we're just saying what goes on, and so people can draw their own conclusions. Fact-finding. So, as we said, the documents. So, in Italy, witnesses don't introduce the documents. In fact, court proceedings in Italy are pretty much based on documentation and on written memorials containing the legal arguments from an early stage, as I said. It will come as no surprise that there is no discovery in Italy, and the parties are required only to, or will only produce documents in their favour. Witness is very little, so that hasn't been an influence in the international arena where we have witness statements and so on, whereas in Italy, witness evidence is very reduced and not done through at all through witness statements, but through heads of evidence, which a judge may decide to admit or not, and frequently decides not to admit if not considered relevant and material. Will I say something about experts very briefly? Italy has a system where you have court-appointed experts. The judge will decide if a court-appointed expert is necessary or not based on the submissions of the parties. Normally, a party will appoint its own expert, and then there will be a mini procedure concerning the preparation of the expert report by the court-appointed expert. The party-appointed experts will see the draft and be able to comment and so on. So that's the system in Italy with respect to experts, and this may be a trend which is also moving into international arbitration. Doug might want to say something on that later. So Courtney says. There will be terms of reference, let's say, which are prepared by the judge for the court-appointed expert. I will stop there because I think Courtney just wants to speak about one more thing, that is the management of an arbitration, and then we can go over to questions.
That's right. Thanks, Andrew. So one more topic we wanted to cover, case management. It's quite a broad topic, but especially coming from, being studied in a Swiss civil system here, it's interesting to see the blush that can have in arbitration proceedings. So starting from the start, at least from the Swiss civil law perspective, it's not uncommon for Swiss trained chairs to adopt a quiet and interactive approach to case management, including to facilitate the resolution of disputes. Now, the interactive role of judicial makers has a long history in Switzerland. It traces back to its origins of the duty of Swiss judges to provide guidance to parties, and it also traces back to Switzerland's tradition of international diplomacy. Now, interestingly, over time, the Zurich Commercial Court developed a practice whereby the presiding judge would convene a hearing, usually after the first round of submissions, in which he or she would express his or her preliminary views into the evolving understanding of the case and indicate the factual and legal points on which he or she would like to hear more, without prejudice to him or her revisiting their views as the case further develops. I understand there's a similar legal tradition in Germany, and I see Marielle Dempsey's on the line, so I'm also speaking under her control, having worked in Germany for quite some time. Now, the tradition of active case management and settlement facilitation in Switzerland appears to have, and Germany, have influenced arbitral practice in two ways. And the first influence we see is that certain institutional rules and soft law provide the settlement facilitation within proceedings, arbitral proceedings, where desired and explicitly agreed by the parties. So I note the Swiss rules and the DIS rules have, since their inception, empowered tribunals to facilitate settlements at any stage of an arbitration. And since 2012, the ICC rules do as well. We also see settlement facilitation proceedings in the CEDR rules for the facilitation of settlements in international arbitration, the IBA guidelines on conflicts of interest in international arbitration, and the Prague rules. And by contrast, with common law influenced institutional rules such as the SIAC rules and the LCAA rules, reference is made to what tribunals are empowered to do in the event of a settlement of dispute, but there's no empowerment of a tribunal to facilitate a settlement per se. So that really is a civil law flavour trickling through arbitral practice. Now, the second influence we see is that soft law encourages tribunals to play a direct and interactive role in proceedings. We look at Article 2 of the IBA rules and the taking of evidence. This provision encourages tribunals to actively consult parties on evidentiary issues, including by notifying parties of any issues that it may regard as relevant and material to a case, and or for which a preliminary determination may be appropriate. The Prague rules also set out a framework for a proactive tribunal with respect to the taking of evidence, aligning with the inquisitorial approach under civil law. Now, further to these developments in arbitral practice, there are increasingly calls by colleagues in our community for tribunals to more actively manage arbitrations, including by engaging in settlement facilitation. In the interest of time, I'll just draw on two recent examples that were discussed at the 2024 ICA Congress in Hong Kong, which a few of us all attended. Now, in the first example, Christopher Campbell, a US-trained lawyer working at Baker Hughes in Florence, advocated for a concept called arbitrator foresight. And he explained this concept as being one whereby tribunals, with parties' consent, would offer preliminary, non-binding insights into their thinking of the case, ideally just after document production, as a possible off-ramp for settlement. Now, in the second example, US arbitrator David Ribkin discussed his town elder rules, which is designed to supplement and amend the on-the-trail arbitration rules. And according to these rules, tribunals should be actively involved in each step of the arbitral process and determine in consultation with parties what evidence or arguments should be presented, how and on what timeline. I won't go into the detail of these rules, but some of the features are that, for example, in the tribunal's first meeting with the parties, the tribunal would discuss in detail with the parties the questions, big questions such as their respective positions, the best means of presenting arguments and evidence, the type of decision that the parties need to put an end to the dispute, and the time by which they would need a decision. And then on the basis of that detailed discussion, the parties would work together with the tribunal and form a decision tree or a roadmap leading to a final decision, setting out the main issues in dispute, the sequence in which these issues would be addressed, and the different phases or steps in which the arbitration would be divided. And additionally, according to the town elder rules, with the parties' permission, the tribunal would make suggestions to the parties designed to lead to a settlement. Now, these innovative ideas discussed in relation to arbitrator foresight, and the town elder rules echo the interactive approach to case management and also settlement facilitation, which are principles and traditions long existing in the Swiss, German and German legal traditions. And these traditions may very well trickle down into practice, at least with tribunals from these jurisdictions. So there's, some of the more Germanic influences that I've seen in arbitral practice, but again, very much speaking under Mariel Dempsey's control. But be interested to hear your view on these. Andrew, have you noticed any of these civil law influences in your practice in Italy?
In short, no. There has been in Italy, the judge tends to take, apart from what I said with respect to deciding on the admissibility, let's say, of witness evidence and areas such as court-appointed experts, the judge in Italy remains pretty passive. And there is a great caution, for instance, the Milan Arbitration Chamber, which is the leading chamber in Italy, is very cautious about arbitrators acting as facilitators for the purposes of settlement. Of course, if you go, if there is a request for mediation, then it will be sent off to a separate mediator, and the arbitrators will step out of the picture, or the proceedings will be suspended.